Hello everyone, I'm Ganu. Sometimes we must protect even things we don't like. The Supreme Court once protected the most racist newspaper in America, and the spirit of press freedom traces back to the decision J. Near v. Minnesota. In 1927, a man named J. Near ran a local newspaper called the Saturday Press in Minneapolis, Minnesota. The newspaper was literally ugly. He wrote about anti Semitic, anti black stuff and spread fake news and rumors about the mayor and the police chief. He was probably the most he was probably the most diabolic man in Minneapolis. So Minnesota had shut down the Saturday Press under this under the Minnesota gag law, which allows the court to shut down malicious newspapers. Near thought the enforcement had violated his freedom of press. So, this case goes to the Supreme Court of Minnesota. The Minnesota Supreme Court had upheld the Minnesota gag law since they valued protecting public safety. They thought the Saturday Press could disturb peace or provoke incitement. Plus, the court believed the Minnesota's Constitution's article about the freedom of press wasn't intended to protect publication of those malicious things, but to protect some good stuffs. Finally, the case goes to the Supreme Court of the United States. The Supreme Court had upheld Near to for 5-4 decision, and the decision had two main points. First, the court believed the 14th Amendment's term liberty included the First Amendment. According to the 14th Amendment, state government couldn't deprive citizens' liberty, which includes freedom of press, without due process of law. And the contemporary interpretation for due process of law states there are some rights a government can't simply take away from its citizens, since some rights are naturally given to the people, and that makes some ugly laws to lose their legal legitimacy despite being made in democratic process. Second, the prior restraint was unconstitutional in almost every circumstances. The court thought the First Amendment wasn't intended to protect only good process but ugly ones too. So technically, if if it is needed, the government could punish malicious presses after the publication, but cannot ban a press before it is released. That was because the prior restraint had a potential danger of being abused as a tool to manipulate presses for media blackout. The case near Minnesota had banned prior restraint in our nation. Since every person should be equal before the law, sometimes it is inevitable to protect things we hate to comprehensively preserve a particular value, and this case was a good example. Thank you for listening.